I'm really excited to hear from Professor George Thomas today as well, and I will just encourage you all, if you have questions, burning questions, ask them. Stand up and share your thoughts, and let's hear from our great speaker. But first, special thanks to Professor Bell. I'm delighted to welcome all of you here to Knox's Constitution Day event. As many of you know, the Constitution Day is observed each year on September 17th, and throughout the week at many colleges and universities across the nation. Today, we are delighted to welcome Professor George Thomas, who I just met a moment ago, the Burnett Woolford Professor of American Political Institutions and Director of the Salvatore Center at Claremont McKenna College, as our special guest speaker today. I got to tell you, I absolutely love the title of Professor Thomas's book and lecture today, The Unwritten Constitution. When I speak about the power of a liberal arts education, I often discuss the impact of asking critical questions, engaging in rich dialogue, researching scholarly texts, and seeking evidence to strengthen one's argument or perspective. In many respects, the truth of a liberal arts education happens outside the words. Just like the Constitution, a 200-plus-year-old document that continues to serve as a foundation for our civic life. This year's lecture focuses on the unwritten ideas that inform our interpretation of that written text. I look forward to learning more from our esteemed guest, Professor Thomas, this afternoon, and now would like to welcome back to our podium our very own Professor Thomas Bell to provide a formal introduction. Thank you.
Thank you, President McGadney. I'd like to introduce our great and esteemed speaker today. When we started thinking about what a great Constitution event would be, I couldn't think of anyone better to invite than Professor George Thomas, whose scholarly work has actually been really influential in my own writing and scholarship. And so let me read you a quick biography and then welcome Professor George Thomas to give a lecture. George Thomas is the Burnett C. Woolford Professor of American Political Institutions and the Director of the Salvatore Center at Claremont McKenna College. Professor Thomas has authored books such as The Unwritten Constitution, which will serve as the basis of today's lecture, with Oxford University Press in 2021, The Founders and the Idea of the National University, Constituting the American Mind, with Cambridge University Press in 2015, and The Madisonian Constitution with Johns Hopkins University Press in 2008. He's also one of the co-authors of American Constitutional Law, Essays, Cases, and Comparative Notes, which is the constitutional law textbook that we use here at Knox College. He's also the authoress of numerous scholarly articles in American constitutionalism, and his work has appeared in popular journals such as National Affairs, The American Interests, as well as the Washington Post and The Atlantic. He's received fellowships from the National Endowment for the Humanities and the Huntington Library, and is the recipient of the Alexander George Award from the American Political Science Association. So it's my real privilege and delight to welcome Professor George Thomas to give this year's Constitution Day lecture.
Am I wired now so I can be away from this, I think? Well, thank you so much for coming, and it's just a pleasure to be here. Thanks to Thomas for inviting me to Knox. I read in graduate school Lane Sunderland's Popular Government and the Supreme Court and was intrigued, and I was a reader on Thomas's forthcoming and excellent book, The Architectonic Constitution, although I understand that the University Press of Kansas is not going to let him keep what I think is the perfect title for the book. But it's a privilege to be here, and all the more so, I'll say, in that... Uh-oh, am I not? I think that's for the audio. Oh, I'm supposed to talk into this. Oh, all right. I gave a lecture. I can stand back a little bit, right? I move a little bit, and I want to be liberated from this a little bit. But I'm also just thrilled to be here in that I knew the A. Lincoln Douglas debate took place in Galesburg. What I did not realize until I was invited here is that the fifth debate, one of the, I think, best in showing Lincoln's arguments, actually took place in Knox College. And I was also delighted to learn Knox's history, and it was Knox for Lincoln at the time, so I'm thrilled about that. And I maybe will weave Lincoln in a little bit in terms of the talk. So let me flip this since I need to be kind of over here. Let me start by saying I want to make two simple points, I hope not simplistic. And those simple points are that in interpreting a written constitution, our written constitution, we inescapably rely on unwritten understandings to make sense of the written text. It's a feature of our written constitution, and our most important constitutional debates turn on unwritten understandings. The second point is that this means our understandings of the written constitution are going to rely on judgments that are not themselves rooted in text. There is no escaping this. There is no safe place to turn, as I put it in the book. Now, those points might seem obvious, and I want to, in a moment, explain why I think it's essential that we maybe relearn them today. But to make my case, I'm going to return to an early constitutional debate from the late 1790s over the meaning of freedom of speech in the press. And this debate, I argue, turned almost entirely on how we understand Republican government and the American Revolution, which determined how those actors read the constitutional text. And I want to highlight something before I turn to this debate, and that is this is a debate that largely did not involve judges. It does in a way, but it certainly does not involve the Supreme Court. Instead, constitutional meaning was constructed by ordinary citizens, by journalists, by editors, by representatives arguing about what the freedom of speech and the press must mean in this new Republican form of government. And I want to put that as a contrast to our current and contemporary constitutional debates, where we seem to be focused and preoccupied by judicial and legal understandings and act as if the court and the court alone is the interpreter of the Constitution. And I think that that miscasts our history. And you should look forward to Professor Bell's book when it comes out, because it makes this point, especially with regard to the president and Congress. But today I want to talk mostly about journalists and citizens and figures like James Madison, but Madison actually is a citizen writing at the time, and I think it offers a take on the Constitution that's a corrective to the legalistic Constitution and to a Constitution viewed wholly through the lens of the Supreme Court. So let me use that to say why I think this point about we rely on unwritten meanings, and those unwritten meanings determine our interpretation of text, and that's inescapable. Because we might say, this is obvious. And I don't deny, in some sense, that it's obvious, but I think it's a thing we overlook today. And we overlook it because we have a set of originalist jurists, and I don't want to be just critical of originalism, because I've got sympathy for it too, and I'll get to that as I go, but they tend to deny this point. And they tend to insist that either your interpretation is grounded in the Constitution, by which they mean the text of the Constitution, or it's a departure from it. And this sentiment has come to frame public debate about constitutional interpretation, and especially discourse on the Supreme Court. So, for example, the late Justice Antonin Scalia, who really frames this debate for our current Supreme Court justices, and if you think of all three of the recent appointments to the court by President Trump, even President Biden's appointment of Ketanji Jackson Brown gave a nod to Justice Scalia in her confirmation hearings in some ways. But when we turn to those figures, they all praise Justice Scalia and insist they want to follow a jurisprudence rooted in Justice Scalia's ideas. That is, a jurisprudence of original public meaning, which I'll explain a little bit more in a second. So, for instance, praising Justice Scalia at his confirmation hearings, Brett Kavanaugh pulled out his well-thumbed pocket Constitution and said, we need to be interpreting the precise text of the Constitution. And if we're not interpreting the precise text of the Constitution, we're going beyond the Constitution and putting our judgments in policy, morality, philosophy, something that is other than constitutional reasoning. And I think he's right that you should read the Constitution. That's where you should start. Don't you give out pocket constitutions as event? When you give them out, pick the Constitution up, read it, look at it, but then ask yourself, okay, does the Constitution allow the executive to pardon him or herself? Does the Constitution say that presidents are subject from criminal prosecution for their official acts? Can Congress delegate its power to the executive branch? Where's the power of judicial review from the Supreme Court? And I want to posit that when you read the text of the Constitution, the text will not answer those questions for you. That doesn't mean you simply depart from the text, but it means we've got to go beyond the text to answer those questions. That the very nature of the written Constitution relies on unwritten ideas. Not, I want to be clear, because we're trying to rewrite the Constitution to make it accord with our policy preferences, but because the text does not explain itself. Indeed, the meaning and significance of a written Constitution is itself the subject of debate. In Federalist 37, James Madison, right, the father of the Constitution, pointed to the limits of language in conveying complex ideas and concepts by way of the text, going so far as to say, when you have complexity and novelty of the objects defined, right, can't be captured by words and words alone. So moving beyond the text is an inescapable feature of interpreting the written Constitution. This is true for textualists and originalists as much as it's true for anyone else. And since we're here at Knox and we have the Lincoln-Douglas debates, I invite you to go reread the 5th Lincoln-Douglas debates. And when Lincoln is saying free blacks can be citizens of the United States, and when Lincoln is insisting that we should prohibit the expansion of slavery in federal territory, and that the Constitution is at root anti-slavery, and so we ought to put slavery on the ultimate course of extinction in order to live up to the Constitution's aspirations. You might be right on all of those issues. Not one of those issues is resolved simply by opening your pocket Constitution and turning to constitutional text. They all rely, and they're all powerful judgments, but they all rely on Lincoln's understanding of the Declaration of Independence and the underlying ideas, especially about human equality, that he thinks the Constitution embraced, but not in its textual form. So this argument, I want to be clear, is hardly news to a lot of originalists. And so I don't want to be understood as just taking objection to originalist arguments. But I think there's a disjunction between the public face of textualism and originalism and the scholarly literature that has grown up around it, which is often very sophisticated. But whether you're in the halls of Congress or you're on courts or in federal courts or the Supreme Court, there's a tendency, especially by originalist jurists and their defenders, to deny the point, which is why I want to insist that we need to bring that point back. Now, let me turn to 1790s to illustrate and illuminate my argument. In 1798, the Sedition Act invited profound debate over the vital principles of Republican government in America. And those debates informed how we read the written Constitution. This was a debate about the very nature of constitutional self-government. So you get the First Amendment passed in 1791. Right? It's actually, and this should make you think about the written Constitution a little bit, it's actually referred to in 1798 as we're debating the issues by people like James Madison and John Marshall. The First Amendment is referred to, the third article as amendment, because that's what it was when it was put before the states. I mean, so that gives you some indication of how we're even thinking about the written Constitution in 1790, because it's not really yet fully formed in terms of the Bill of Rights. We don't now, we don't in 1790s even call it the Bill of Rights. But so against this backdrop in the 1790s, the Sedition Act of 1798 made it a crime to write or speak false, scandalous, and malicious things against the government with the intent to defame it or bring it into contempt or disrepute. Now, it was passed with the Alien Act, and I don't want to talk about it as much, but they go together in the sense that the Alien Act was also an act to try to not just stop immigration, legal and lawful immigration at the time, but also potentially deny lawful legal aliens in the country, but to deny them rights that they were exercising as citizens, and there was a big debate about whether they were citizens or not. And so the Alien Act comes up with the Sedition Act in many ways, and they intersect on occasion. But the important point here is that the Sedition Act, passed by the Adams administration, right, makes it a crime to defame the government, right, the sitting president especially. And I want to go through it as I go to speak to some of the cases. Now, one qualification about the act, and this might seem interesting to those who don't know the history, unlike the traditional common law of seditious libel, which I'll explain in just a second, the Sedition Act of 1798 actually allowed truth as a defense. And so the idea is, if the things you were saying about the government were true, then you could say, but I didn't defame the government, these things are true. And this, many Federalist jurists said, was a great improvement on the common law, and it would make the Sedition Act not subject to the kind of criticisms that James Madison and other would insist upon. Now, for reasons I'll get into, Madison's going to say that doesn't really work and it doesn't get around it, and what you're ending up doing is criminalizing differences in political opinion, right? But this argument, right, is a great question about, so what does the freedom of speech and the freedom of the press mean? So we've got constitutional text, and the constitutional text is clear. It says, Congress shall make no law abridging the freedom of speech or of the press. There was almost no disagreement on the text, right? Those who said the Sedition Act was perfectly constitutional pointed to the text and said, yeah, it allows it. Those who criticized it said, I'm on the text too, and it doesn't allow it, right? So the debate turned almost entirely on their unwritten ideas. It was a debate about the freedom of speech and the press. What did they entail, right? And that debate was inseparable from the kind of government the new Constitution brought into being. So the text points to concepts, but those concepts must be situated politically, historically, and philosophically. So defenders of the Sedition Act turn to the British common law inheritance as framing the meaning of freedom of speech and the press. The critics rejected the British common law inheritance for reasons I'll get into, right? So the Sedition Act forced Americans to wrestle with the meaning of freedom of speech in the press in this new context. And I want to say that it's these sorts of instances, things we didn't necessarily think about in the past, that forced their way onto the political community, and then we have to wrestle with the underlying ideas to make sense of text. And I want to suggest that this is different from most originalist accounts of the Constitution. So the idea in originalist terms, so what does freedom of speech or press mean? It means you would turn to what the freedom of speech or the press meant to the ordinary reader at the time the text was ratified. So in 1791, when the Bill of Rights is ratified, you would turn to what an ordinary reader thought about the text. The originalists these days call this original public meaning. And the idea is that, right, the public thought something about the First Amendment, and so you go back and you discover what is it that the average person would have understood at the time. And what I want to submit by turning to the actual and real history is they debated that, right? There wasn't latent meaning in the text in an easy way where you could just draw it out. Rather, what's going on is they're forced to actually think, wait, what does freedom of speech and press mean in this newly formed Republican government? In this popular government, different than the common law under Britain, where we had a monarchy. So do you need to reframe and refigure how you think about and contextualize freedom of speech and the press? And that's the debate I want to look to. So let me first start then with the Federalist side of things, and with justices like Samuel Chase and James Iredell, two of the first appointments to the Supreme Court, who turned to the common law jurist William Blackstone to gloss the meaning of freedom of speech and the press. And both Chase and Iredell argued that punishing seditious libel was entirely consistent with freedom of speech. As Justice Chase put it, a licentious press was particularly harmful to the Republican form of government because it could corrupt the public opinion and destroy the morals of the people. So it was imperative that such speech be punished to protect the government in a republic. So for them, the common law simply meant that the common law inheritance simply meant that you could not punish speech before it was published, so there was no prior restraint. You couldn't prohibit somebody from publishing something, but you could punish them after the fact if that speech defamed the government. Now think of the common law for a minute, because the common law didn't actually allow truth as a defense, which might seem a little bit weird, right? So in some sense, right, the common law was like, if your statements were true, it was even worse, because it would really defame them. So you could say true things about the government, where nobody would dispute them, but you could be punished because then it was even more defamatory, right? I mean, so there is this idea that there's a great innovation here. The Sedition Act allows truth as a defense. But Samuel Chase, Justice Iredell, and almost all of the justices on the Supreme Court, with the exception of James Wilson, thought that prior restraint was essentially the rule the First Amendment brought into being. That is, no prior restraint, but you could punish after the fact, right? And Chase, incidentally, is the only Supreme Court justice, and you'll kind of see why in a little bit, that was impeached, but he was not removed. It fell a few votes short of removal at the time. But so Chase and Iredell and others argued that when it came to thinking about government and freedom of speech, and put this in the context of popular government, how we think about elections, how we think about emerging political parties, this is all, I think, part of the story. So Chase acknowledges that elections are important, but he wants to make the argument, and he does make it on the bench, that once you've had an election, the minority must surrender up its judgment and acquiesce to the government in power. As Chase puts it, they have to surrender their judgment. Indeed, Chase went so far as to argue that private opinion must give way to public judgment, or there must be the end of government. So only those the nation has chosen by way of elections could then weigh in on public issues and speak to such questions. So to persistently criticize the government with improper motives, trying to influence what the public thought, right, and trying to bring the government into disrepute was unacceptable for Chase. Indeed, in a few cases, so I've got 3 names for you in trials that I won't go into all of the details, but you might be interested in looking up. Thomas Cooper, educated at Oxford, he's a newspaper editor, comes over to the United States, and he's a severe critic of President Adams. And he criticizes President Adams for all sorts of reasons, right? Including thinking that he's leading us into war, that he's preferring Britain to France, and that part of what he's doing is cracking down on lawful residents who should be treated as citizens. This is the alien part of the Sedition and Alien Acts, and that he's attempting, in this particular case, to silence his critics. In fact, at his own trial, where he acts as an attorney, Thomas Cooper gives the facts of the case and says, this is why I think, here are the facts that I'm submitting to you, this is why I think all of my opinions about Adams, all of my judgments about Adams are in fact true. But Chase then says, he's the justice presiding over the trial, Supreme Court justices at the time, actually sat on the lower courts and even sat on trial courts. When Chase instructed the jury, Chase said that it wasn't for Thomas Cooper to make these judgments. The country had elected John Adams as president, and it wasn't now for Thomas Cooper to, quote, bring Adams, it wasn't for Cooper to make such judgments and write them, print them, with the intent to bring the president into contempt and disrepute and excite against him the hatred of the people. So he said this was not Thomas Cooper's job. Thomas Cooper can't make this judgment. Thomas Cooper shouldn't make this judgment. We had an election. Adams was elected. It was now Thomas Cooper to acquiesce, right, and other journalists and citizens. So just a couple of more instances of this. James Callender, who was born in Glasgow, came over, was also a journalist, a Jeffersonian. These are all Jeffersonians, right? Also critical of John Adams at the time, right? And Adams was, you know, a little temperamental and didn't really like to be criticized. He was the only president until 2000 that didn't attend the inaugural of his successor. So, you know, there might be some similarities with Adams and other presidents, which is kind of interesting, because on the other hand, you'd think he'd be far, far away from him. But so James Callender, also subject, and by the way, Thomas Cooper's fined $400 and sentenced to 6 months in prison for his criticism of John Adams. So James Callender, similar criticism of Adams. He says that he's getting us into war, and he's on the wrong side of things. He's also trying to round people up and silence them. So again, deeply critical of Adams, also makes his case to the jury. Chase presides over his trial as well. And Callender also insists, look, here are the facts, right? I think based upon these facts, my opinion is that John Adams is acting in ways that are inconsistent with Republican government. John Adams is no George Washington, he says. He's not living up to this model, but he offers this as his opinion based upon the facts and insists in his trial. He says, I think that if you disagree with me, this would be much better done by argument rather than by indictment, right? Pointing to the very notion of the fact that they're trying to indict him for his political opinions is an improper way to deal with his criticisms of John Adams. James Callender is fined and sentenced to 9 months in prison for his criticism of Adams. Let me give you one more. Matthew Lyon, a representative from Vermont. He too makes an argument criticizing, first in the House of Representatives, against the Sedition Act. He's like, look at what Adams is trying to do. He's trying to silence us. He's trying to quash public opinion and criticism of him, which is unacceptable in a popular government. So Lyon makes that case, and then he proceeds to make it as a representative in Vermont. He too is charged under the Sedition Act. He too, and I won't belabor the points, but he too says, well, here are the facts, right? Here are the things that Adams has done, and this is why I think those facts, right, justify my political opinion, my judgment that Adams is unfit to be president, and we would be better off with a new president. Lyon too is found guilty, fined, and sentenced to prison. He has a little bit of a happy story in that he is actually reelected to the House of Representatives from prison in Vermont. So, and I'll give you just one more instance. I won't go over the particular figures, but for instance, in Massachusetts, having a conversation in a tavern, one gentleman says, he doesn't particularly care for John Adams, and he's later charged with that criticism of John Adams. They actually fly a maypole saying death, they don't name Adams, they say death to tyrants, praise the Vice President of the United States, Jefferson, and the people who put it up are charged under the Sedition Act. So there were real instances of people being criticized for and then tried for the political opinions they were issuing against the sitting government, especially President Adams. Now, it's in this context that not only do the newspaper writers like a Cooper and a Callender, or representatives like a Matthew Lyon or Albert Gallatin, who will become Jefferson's Secretary of the Treasury, also from the House of Representatives, right? They engage in criticism of the act, but their argument is the Sedition Act is not compatible with freedom of speech under the First Amendment, not because the text makes it clear, because it goes against popular government, right? And the very logic of the new republic we just brought into being. Now, the most powerful exponent of this, and again, I want to highlight the fact that you have a judge, Supreme Court justice in this case, making these judgments, and a number of Federalist judges make these judgments, including multiple Supreme Court justices, not just Chase, with the exception, again, the honorable exception, I would say, because I think he's probably the second most important person at the Constitutional Convention, and that's James Wilson, and probably the greatest legal mind of his generation, and he thinks the Sedition Act is unconstitutional, but he's a real exception to the Federalist at the time. But I want to emphasize that this is a political debate. These are important constitutional questions being debated by representatives, by ordinary citizens, by journalists, by editors, and by figures like James Madison. So James Madison, right, often thought of as the father of the Constitution. He had served at this point 4 terms in the House of Representatives, and he would soon be Jefferson's Secretary of State. But at the time of the Sedition Act, Madison is an ordinary citizen, and Madison takes up his pen to criticize the Sedition Act, and he wants to criticize it on the grounds that it's simply incompatible with the American scheme of government, right? It's utterly and profoundly at odds with Republican government. And so he has to draw out the logic and nature of popular government to make this point. And Madison does that in first, it's called the Virginia Report, and then a series of resolutions you may be heard of, the Virginia Resolutions. And Madison sends the Virginia Resolutions to Congress and asks Congress to repeal the unconstitutional act, and also sends them to the other state legislatures and asks the state legislatures to repeal or voice their opinion against the Sedition Act so that Congress will repeal it. And there's an interesting moment here too. A couple of the states write back, Massachusetts, Rhode Island, and Vermont, and they all say, and so this is a debate I want to, I don't want to dwell on here, but I want you to think about, because it starts from the beginning, and their response is, hey, who are you, James Madison, ordinary citizen, or who are you, Virginia, to weigh in on constitutional questions? You don't get to weigh in on constitutional questions. This is for the Supreme Court to decide, right? Now, Madison thinks that that's wrong. Madison's going to weigh into it along with, right, all the other folks I've been pointing to. But Madison's argument is that to understand the foundations of the Constitution, we need to understand the revolution in government that just occurred. And his argument largely turns on the nature of Republican government, and he reads the text, right, which again, nobody's disputing. Everybody agrees. Congress shall make no law abridging the freedom of speech or the press. The whole question is, does the Sedition Act of 1789 do that? And Madison says it does violate the Constitution, and it violates it because this common law inheritance that Chase and Iredell are pointing to, and other Federalist jurists, and that John Adams and company are relying on, is not consistent with Republican government. And Madison says this common law inheritance, is this idea of the freedom of press, can never be admitted as the American idea of it. And it's because there were essential differences between the British Constitution and the American Constitution. In the American system, Madison argued, power flows from the people, which requires a more robust conception of freedom of speech, allowing the people, as popular sovereign, to criticize the government, even to defame it if they think it deserves defame. It was acceptable, Madison said. Indeed, it was obligatory as a constitutional matter to allow citizens to defame the government if they thought the government ought to be defamed, right? That was a judgment for citizens to make, not the government to make. So Madison's, or the thrust of Madison's argument was that while allowing truth for a defense might seemingly let you off because you could point to the facts somehow and that would work in your favor, Madison said, no, the problem with this is it's going to criminalize differences of political opinion, right? And he pointed to what was going on with Cooper and Callender and Matthew Lyon and the like to make the case. Now, I want to turn here and read you a couple of quotes that I think illustrate Madison's argument from the press in this day. So start with, a Jeffersonian press, right? And I would have said 5 years ago, if you think of our press as disappointing today, go back here and there's room to get worse. That's less so today. But so here's a Democratic Republican paper. It calls Adams a liar whose office was a scene of profligacy and usury. He was then dubbed a hoary-headed incendiary, this is actually Thomas Cooper, whose hands are reeking with the blood of the poor, friendless Connecticut sailor, and his purpose was to embroil this country in a war with France. Now, just thinking about Madison's argument and the kind of argument Madison was making, he said, the problem here, right, is that how do you separate the fact from the opinion in a statement like this? Now, on the one hand, this might just seem like, look, this is, do you have to be quite so incendiary? But there are real issues here, right? And the real issue is especially when he says, whose hands are reeking with the blood of a poor, friendless Connecticut sailor. One of the great issues debated at the time was when Adams turned over a figure he said was a British sailor who had escaped from the Navy, and the British were asking for him to be returned. Adams turned him over, right? Taking the British at their word without any kind of trial or due process. So Adams was like, look, he's British, I've got to turn him over. The Republicans were like, well, he might be British, but he says he's not. And insofar as he says he's not, he needs and is entitled to some kind of due process. So it's not okay that Adams simply turn him over. So it was also a debate about the executive power, right? Which again, you could turn to Article 2 of the Constitution and say, well, the executive power is vested in the president. And again, no one denies the text, right? The executive power is vested in the president. The debate is entirely, well, what's the executive power? You have to turn to unwritten understandings to make sense of that debate. And it was a debate that Hamilton and Madison also engaged in the 1790s, dividing as Federalists, right? I mean, taking very different positions on this. But Madison's point was that when we turn to political opinions, right, we're going to not just be disputing facts, we might dispute facts, but even if we can agree upon the facts, the ideas we draw from those facts, the inferences we draw from those facts, those are going to be disputed, and that is precisely what he worried the Sedition Act was criminalizing. So now you could turn to a Federalist paper, and they actually look like they have a little bit more talent for invective in a way. So the Federalist Press, engaged in these similar arguments, and a Federalist newspaper, speaking of Jeffersonian Republicans, said, they are the refuse of nations and frog-eating, man-eating, blood-drinking cannibals, right? So how do you determine the truth of that opinion? And again, while this might seem like it's all a little over the top, there are, you can almost hear right there in echoes, like they're eating the animals, the pets, excuse me. They're eating the pets. So this might seem like a little bit over the top, but there are real issues here, right? So when you think of the refuse of nations, it's a clear reference to the Alien Act. One of the big debates going on at the time was who should be an American, who was properly admitted, right? if, again, and you have Samuel Chase's impeachment, as Mark Twain famously said, right, if history doesn't repeat itself, it rhymes. So there's, I think, some of that going on in the 1790s and 2020s. But when you think of refuse of nations, it's a debate. Who can come over to America? What should immigration laws look like? Who's allowed in? And Federalists were deeply skeptical about allowing, especially the French in at the time, right? Were they consistent with our Republican scheme of government? Would they be good Republican citizens? It was hardly only the French, but certainly there was worry about that. So you have this debate, who belongs in the nation? That's a real debate, and it's a debate that needs to occur, and they're a debate with serious differences of opinion. When you get to frog-eating, man-eating, blood-drinking cannibals, maybe it gets a little bit harder, but the frog-eating is actually sort of obvious. Again, a reference to the French, because one of the great debates going on, and one of the reasons that Adams turned over a person he said was a British sailor and pressed into service, although the Jeffersonians said, no, he's an American and he shouldn't go there, was because Adams was trying to curry favor with the British. And that's one of the basis of the criticisms Republicans were making of Adams at the time. So again, a critique of the Jeffersonians and the Republicans for being too close to the French. When we get to man-eating, blood-drinking cannibals, I'm less sure, but certainly there was an argument going on at the time about questions around the French Revolution and whether or not the revolution was spiraling out of control in a way that Federalists were really worried about, right? And that bringing the French over, while they looked like they were on the surface maybe consistent with Republican government, it's, less clear that they might be. So again, while there's serious invective, these are real issues. There are real debates underlying what's being put in the newspaper. How do you sort out the fact from the opinion in this case? And that was Madison's point. And so Madison wanted to argue you couldn't do that, right? Because too often, or so often, political opinions rely on, a particular reading of facts, and then you draw inferences from them. And the problem with the Sedition Act was that it was criminalizing and punishing political opinion. And he could point again to Thomas Cooper, James Callender, Matthew Lyon, and others, and say, right, that what they're being punished for is not that they defamed John Adams in a way that couldn't be proven, but the facts they insisted on were true, and then they drew their political opinions from those facts, right? Federalists might disagree. They might think that was good cause to support Adams. And part of what I want to then insist is that these events forced the political actors at the time to think through and wrestle with the meaning of freedom of speech and the press, right? The textual meaning was being constructed based upon a political theory that underlies the Constitution, right? And so arguments against the Blackstonian understanding of freedom of speech and the press were part of creating a Republican government rooted in individual rights and popular sovereignty, a government that provided for robust political dissent against the sitting government, right? And so Madison can be understood at the time as trying to create a political party, right? This is the emergence of the party system that would embrace these understandings, and he was constructing constitutional meaning rather than just turning to text and drawing it out in some, as if it was, that its latent meaning was there all along. And he was arguing that this was a sense that the people should attach to the freedom of speech, right? I mean, so there were these development of these ideas over the 18th century, and I want to say that Madison's engaged in, first of all, and it's not just Madison, I think he's maybe the most powerful expositor of the idea at the time, but again, I don't want to lose sight of a Thomas Cooper, a James Callender, Matthew Lyon, and the ordinary citizens, right? The ordinary citizens, the guy at the bar who made an offhanded comment about John Adams and then found himself later on being charged because somebody snitched on what he said at the bar. I mean, ordinary citizens were like, well, wait, don't I have a right to criticize, indeed to defame John Adams if I think he should be defamed because of the things he's doing? But Madison was trying to, by way of the Virginia Report and the Virginia Resolutions, actually educate the public, right, and persuade the public that this would have to be the understanding of freedom of speech and the press if the government was to genuinely be popular, if the government was to genuinely be rooted in this idea of popular sovereignty, if it was to be a truly Republican government, which would have to break with the monarchical understanding of freedom of speech being put forward by the likes of Chase and Iredell and other Federalists. And I want to quote Madison at length, and it's a little archaic in terms of the language, but I think it gets at his idea that free speech in the Constitution has to be read in light of Republican government, which we hadn't thought fully through, and contrasted again with this British inheritance, which we would have to break with. And so this is Madison, quote, "The nature of governments elective, limited and responsible in all their branches may well be supposed to require a greater freedom of animadversion than might be tolerated by the genius of such a government as that of Great Britain. In the latter, it is a maxim that the king, an hereditary, not a responsible magistrate, can do no wrong, and that the legislature, which in 2/3 of its composition is also hereditary, not responsible, can do what it pleases. In the United States, the executive magistrates are not held to be infallible, nor the legislatures to be omnipotent. And both elective are both responsible. It is not natural and necessary under such different circumstances that a different degree of freedom in the use of the press should be contemplated. So Madison's argument is that Chase and Iredell and company are getting it wrong, right? Not because they're misreading text, but because they're wrong about the underlying ideas that text needs to be read in light of. And so what Chase and Madison were engaged in is situating the constitutional text within their unwritten understandings of the American constitutional enterprise, and they were bringing to life text based upon their readings of political theory in America's Republican form of government. And I want to go further with Madison and note something. And I think you should, and especially I guess here, where Lincoln is so important, you should think that if you think of the debates here, right, they really forge how Americans think about Republican government, not just with regard to freedom of speech and the press, but with regard to political parties, with regard to distinctions that we take for granted, but were in the process of being formed in the 1790s. And that's a distinction like between the government and the loyal opposition, right? Because what Adams and company had done, and what I think Chase and Iredell were doing, was conflating a criticism of the administration with a criticism of the government itself. Now, Madison's clear, you get to criticize the government too, right? But there's a distinction between the administration in power and the form of government, right? So you have to be able to criticize the administration in power. That's part of having elections. And this is all in the run-up to the election of 1800, right? And political parties are going to disagree profoundly and disagree on constitutional issues. That doesn't mean they're being unloyal to the constitutional order. That means they have different conceptions of that constitutional order. And all of those things are being forged by the likes of Madison and Thomas Cooper and James Callender and Thomas Jefferson. And you get the culmination of that, right, with the election of 1800, right? The first true peaceful transfer of power in American history, right? And the Jeffersonians then would come in, and they actually didn't have to repeal the Sedition Act, which gives you a little bit of an inkling of how Adams and company were thinking of it, because Adams and company, when they passed it, already made it expire when their own term ended. So, right, they created a law that they didn't want to be subject to, right, by the Jeffersonians should they come to power. But my point is this is all part of building the American constitutional order, and I want to insist, so when we think of somebody like Lincoln here, to go back to that, right, if you think of probably the most important constitutional interpretation ever made in American history, it was one made by President Lincoln when he said, no, you can't secede from the Union. Free blacks can be citizens of the United States. Equality is part of the fundamental nature of the constitutional order. And insofar as you've now seceded from the Union, I'm going to have to rise up and keep you in it because you don't have a right to secede on those grounds, right? Supreme Court gets to that later on and says, yeah, okay, you're right. But we don't actually think, oh, this is right because the Supreme Court said so in a later case. We think it's right because Lincoln made the argument for it, right? So if you think of Lincoln's understanding of the Constitution, or go back to the 1790s when you have Madison and company, I just want to remind us that some of our most important constitutional debates are debates that occur outside the courts, and they don't rest upon the legal judgment of jurists. They represent the political and constitutional judgments of political actors, and these days we are too likely to sort of shy away from those debates and read things through a court-centric or legalist lens, right? So let me conclude with my second point, really. And I want to say that constitutional judgment then, right, and constitutional judgment that doesn't rest easily on text is inescapable, right? The text is simply not going to answer our most pressing constitutional questions. It answers a lot, right? We don't really debate whether the president should be 35 years of age, whether or not Illinois gets 2 senators, right? We don't debate that senators serve 6-year terms, that members of the House serve 2-year terms, and that presidents serve 4-year terms, right? I mean, all those pieces of constitutional text are clear, exquisitely so, right? And we don't dispute them. But then we have these other pieces of text that we do dispute, like the freedom of speech and the press. And to bring those to life, we're going to have to rely on judgments that are not articulated by the text itself. So what I mean by this, right, is there's really no safe space on which we can stand and simply say, well, the text just settles the question for me. Rather, we have to make judgments about why that text means what we think it means and why the understanding we're putting forward is, we think, the best understanding of the text, right? I mean, why Madison had to say the freedom of speech and the freedom of the press has to allow for not just criticism of the government, but even the defamation of those in political power if we think, as a people or as an individual, that they ought to be defamed and brought into disrepute, right? So the burden is then on us to make the case for why our understandings are the best constitutional understandings. But I also want to suggest this might give us a little bit of humility and pause, right? Because there are other understandings that are pretty powerful, right? And I think too often today, perhaps, we tend to think that one position is exquisitely clear and the other so obviously wrong, and yet then we turn to courts to settle it out. And so knowing that we're going to disagree about some of these things, and that there are reasonable positions on both sides of an issue, or multiple sides, because it's not just that there are always two, but that we have the burden of engaging our fellow citizens and engaging them on constitutional questions, but knowing that in the end, right, all we have really are the arguments we can make. I mean, I'm not saying that's nothing. I think it's a lot. But again, right, Justice Kavanaugh can pull out his pocket constitution and say, look, let's interpret the precise text of the Constitution. But if you run down Justice Kavanaugh's opinions, and I don't mean this as a criticism of his opinions as opposed to a criticism of how he frames the question, they are rarely grounded in the precise text of the Constitution, right? I mean, you should read the text of the Constitution. That's where we should all start, but then we should go from there. And that's the point I want to insist upon. So there's no getting around these unwritten understandings. We'd be better off acknowledging that our judgments rely on these unwritten understandings, but nevertheless, this is the best sense of the text that we're offering. And I want to submit that this is the ongoing project of American constitutional self-government. Thank you very much.
We've got some time for Q&A, and I've got a mic here, and so I can pass that around if there's questions. But perhaps we should start with some student questions first, and before you open it up to everyone.
Hi, wonderful talk. I really enjoyed it. I'm thinking about the very end of your point here. It's about engaging other citizens in constitutional questions, and it reminded me a lot of Stanley Fish in his book. He says that the reader is always making sense, and I'm thinking about that a lot as you're talking. And in that book, he talks about interpretive communities that put the guardrails around these exact discussions that you're talking about. And I'm wondering, does Madison try to put up those guardrails and try to decide, hey, how far can the bowling ball go over before it hits the gutter? Or does he not quite get to that in his work? And if he does, what do those look like?
Well, I mean, no, that's a fantastic question, and in some ways, right, it's the question. And the idea is, right, so if you're working in a space, aren't there certain interpretations or understandings that are just going to be out of bounds altogether? And I think that's probably right, but I guess I would think the guardrails, right, are I would argue in part, and I think this is where, and I'm going to, Thomas, and you should wait for Thomas's book when it comes out, because I think it does a really excellent job of articulating this point. I think the guardrails are sort of multiple, right? But the guardrails are not necessarily placing such a power to police the boundaries in any one particular institution or body, right? That's why I would say a sort of plurality in terms of constitutional interpretation is an essential feature of the constitutional order, where you have not just representatives and senators and presidents making the case, but also judges and Supreme Court justices. I don't want to read them out of the Constitution at all. All I want to say is they're not the final arbiter of constitutional meaning, right? And for most of our history haven't been, but in the last 50 years or so, and I actually think that's very much because we as citizens and the political branches have sort of given them that power, and then they've also said, oh, okay, we'll take it. But we've given it to them in ways, and so I think the policing those boundaries, right, becomes an act of the political community as a whole, right? And I mean, so you could come up with examples that I think are clear violations. Again, you get to serve more than 4 years as president, right? I mean, that's a clear violation of that. Or you could say, look, the 22nd Amendment doesn't apply. I'm going to take a third term. I mean, those are the easy questions because by and large, we don't dispute those, right? But when it comes to freedom of speech, right, then it does get more difficult, right? So can you prohibit speech that might lead to imminent violence? I mean, those are judgments we're going to have to make, and in some sense, my answer I know is unsatisfactory, right? But I guess what I want you to wrestle with is, right, as citizens, you can't escape making those judgments, right? And the best way to kind of police those boundaries is to actually think through the questions and make the arguments. And part of what I want to insist upon, I hope this came out in the Madisonian part of it, is that part of what he was engaged in, right, is an effort to educate his fellow citizens, right, and persuade them of the logic and reason of constitutional government, saying, no, we can't actually be too deferential to the government on this score. So I think you actually need an engaged and thoughtful and critical citizenry, right, if you're going to have real boundaries to that. But constitutional government is sometimes born of disagreement, and that means within a constitutional space, there's going to be a lot of things that we disagree about. And when we disagree about those things, we have to recognize that our fellow citizens often have pretty powerful, or at least reasonable, constitutional arguments on the other side.
Actually, on that last point, if you can elaborate, it's okay if not, but like perhaps elaborating to the extent in which citizen participation can in fact influence the constitutional interpretation and not just leaving it up to the Supreme Court, but how, as a public body, we actually have the power over that.
Okay, now that's again a great question. So hopefully, right, you could see in the 1790s at least, I mean, it's a long time ago, but I mean, when you think of how we understand freedom of speech today, right? I mean, by and large, we mostly accept Thomas Cooper and James Callender and Matthew Lyon's understanding of freedom of speech, right? But they were making those arguments as citizens, right? And I mean, as journalists and representatives as well, but ordinary citizens were making the case, right? And they make a powerful case. And I mean, the downside is, it's not like free speech is then free sailing from the 1790s on. It has its moments and then it retreats, and that shows, right, where citizens come in. But let me give just another example. I think it's much more contemporary in those terms, right? So many people were really upset, obviously, when the Supreme Court overturned Roe v. Wade and Dobbs, right? And there was a real worry that you're taking away a constitutional right that many people think is foundational and are insisting upon it, and they think that the Dobbs decision was a real retrenchment in that sense, right? But if you look at what's spilled out, I'm not saying it's perfect sailing from there, and there's serious dispute about it, but if you look at what's happened in many states after that, right, there's been an insistence that, wait, this is a constitutional right, and citizens are actively working to demand that constitutional right and inscribe that right in their own state constitutions, making the right secure. And I would say that's an instance, I think, of citizens, right, insisting upon a constitutional right or a constitutional understanding and working through ordinary politics to make that right real, right, no matter what the Supreme Court says.
Yeah, sorry. Okay, so this isn't like a fully formed thought.
Those can be the best kind.
Yeah. So I was thinking about the idea of this burden of proof being on the defamer.
Yeah.
I guess this burden of I have to prove that this thing,
It's true.
It's true. And then Brandon was talking about like policing boundaries of what counts as acceptable to say in this like political arena. And I was just thinking about, with our current political situation, how do you police those boundaries, or how do you demand responsibility from a defamer when a large portion of the public believes something patently false?
What are you talking about? No, all right. So that's an excellent question, right? And actually, just one wrinkle to defaming, right? In some sense, and because this actually comes out in later arguments. I mean, there are, right? So if you think of the arguments being had in the 1790s, they were by and large about political figures, right? It was mostly the Sedition Act, actually, and this is another wrinkle that's interesting if you don't know the history. Sedition Act made it a crime to do this to the president and a number of executive officers. It didn't actually make it a crime to do it to the vice president, who happened to be Thomas Jefferson at the time, right? But so there is a serious distinction between, right? And again, we have to work out how we're thinking of free speech. So does free speech, when it comes to criticizing the government, require a latitude, right, that's different than talking about an ordinary citizen, right? I mean, so you can actually win cases when you're engaged in spreading demonstrably false statements about a particular individual, right? And you can actually win that case, and you can even get damages, right? I mean, I think this is maybe what you're referring to. I mean, there was, for instance, a media corporation who settled paying $750 million for things it was saying about the 2020 election, and that's because, right, when they went to court, it was like the things being said were demonstrably false, right? And you had factual statements that were simply not true about them. But notice there's a difference about that, right, than political opinions, right? And especially then the kind of latitude you would give to those who hold political office. And Madison's argument was, right, those who are holding political office are going to have to subject themselves to a bit more criticism, and that even might kind of, run the edge potentially of, maybe even saying untrue things about them, and that we're going to have to allow that. But I think it's a great question. I don't have an easy solution to you. Again, I don't. But I don't know that there are easy solutions, because I mean, disinformation has become a huge problem, right? But is the best way to combat it then to put somebody in charge of saying this is disinformation and we're going to police the disinformation? And that's where, right, I'm not sure that's a particularly good remedy, as opposed to a citizenry and representatives making the case against. And again, it's unsatisfactory because it doesn't always work. But again, that's part of where I think the persuasion and education of citizens is important, right? And I mean, hopefully, right, the kinds of things that Knox is teaching you here are really helping you to sort through that, right? And to be able to sort through what you're seeing is, right, this is just sort of preposterous, and so we need to make clear that it's preposterous and wrong.
I feel bad because I want to keep you here in this place. I'm thinking about Elon Musk, who sucks the air out of every room he walks into. And the way that Grok works to create news based on what people wrote on Twitter. And so in a world where the public voice is so confounded by a technology that very rapidly proliferates information based on whatever that algorithm is doing with Twitter, how are we going to get conversations that are robust, that allow us to navigate these boundaries when some people's vested interests seem to be counter to that and they have more money than we do?
No, that's an again. All right, yeah. So here we are at liberal arts education. I have questions. I don't have answers. So because they're great questions, but I think they're great questions without easy answers. And I mean, so what I would push there, and this, I mean, it's something to really think about. And in the 1790s, Noah Webster, the dictionary guy, who's actually, the dictionary is very much part of a nation-building, citizen-building project, right? I mean, you're cultivating language of a certain sort, really makes the argument that too much wealth in concentrated ways is inimical to Republican government, right? I mean, because it can distort the very playing field, which is, I think, what you're talking about. So, I mean, it's not just an access to information question, right? It's that some people end up, right, with loudspeakers and blowhorns and like, and others are kind of pushed to the corner, right? And how do you say, well, their voices can all be heard? And so, I mean, I think there are real questions about when it comes to the public space and who owns media and the like. I mean, we can think of those in, again, small r Republican terms, and we can ask some of those questions. I mean, is having somebody with, what is it Musk have these days? Is it like $90 billion now, or 80, or, I mean, it's actually, I got to tell you, $1 billion is sort of unfathomable to me. Seems to, if somebody said, you want $1 billion, I'd be like, can we just make it like, 100 million? I'd feel more comfortable with that. No, I think those are real questions, right? I mean, so when it comes to, say, media, right? I mean, can we say that we actually do want to create a space where we clearly don't want to silence people, but that we want to make sure that it's not simply money drowning out, or, a couple of companies with concentrated wealth who run everything. And so I think where you're talking about like antitrust law, things like that, that actually we don't speak of those enough in small r Republican terms. It's interesting that people like John Adams even, right? John Adams, who you think of as a kind of aristocrat, actually really warned deeply about American oligarchy in important ways. Noah Webster again did. So I mean, those I think maybe filtered through that lens with the disinformation. Those are questions we should really wrestle with. And I think the wealth questions again, concentration of sort of media power are legitimate questions when it comes to making a space where the voices of the citizens can actually be heard and not necessarily drowned out. But also, yeah, absolutely.
So the way that Musk's AI project is supposed to work is, quote, the voice of the people, right? Like the more people on Twitter who say something insane, the more likely it then reifies that in an assertion about reality, right?
Yeah.
And so then it really is like about public voice too, and not just money. And how do we fix the public voice?
Yeah, I mean, I guess that's the question, right? But is that the voice then of the people? Because I mean, half of those things aren't necessarily even people, right? That are repeating it. So I mean, I think there's that part of it. And again, right? I mean, I guess I think, and it's not an easy answer, I think there's in some sense sort of no substitute for the kinds of things like Knox is doing, engaged in liberal education, where I mean, if you look at studies really have shown that people with a more grounded civic education and a basic education, college education usually, are much less susceptible to it. Although, right, we've got a bunch of billionaire educated people who, maybe they're proliferating, so they're not susceptible. They know full well what they're doing there. But I mean, and Madison again has this great line, and as much as he's trying to construct a government that doesn't simply rely on the good nature or virtue of the people, he says, look, if there's no virtue among us, then we're in a wretched situation, right? And this is where, don't take granted that constitutional government or liberal democracy just kind of is smooth sailing and it's all going to be fine. I mean, it's got enormous challenges, and these are some of them.
Right, it's kind of a different direction.
Yeah, it's great.
Or either your personal opinion, or if you know of a text that defines his opinion, but what do you think Madison would have thought of in terms of like Constitution reading in terms of like anti-government symbolic speech? If that's defensible, such as like flag burning, armbands, kneeling during the Pledge of Allegiance, like yes, he was very against the Sedition Act and speaking against the president and people, but what do you think he would have thought of symbolic speech against the U.S. as a whole?
I mean, he never dealt with it, but I'm pretty confident I can answer for him on that. No, I think yeah, no, but this is actually one of the things I want to say about when I'm talking about the unwritten Constitution, and I want to be clear, like right, because it's not neglecting the written Constitution. The is parenthetical because you're inevitably, when you're reading the written, reading kind of the written in it, and there's no. So when I'm making the argument, it's not like there's text and these other things. The text and these other things are really wed together, and you can't read the text independently of the idea of what it is and the understandings you bring to it. But so it doesn't matter so much that Madison wasn't thinking of these things. If you take his principle and put it into play, I mean, I think those kinds of questions are fairly easy to say that. I mean, of course you can criticize the government, right? I mean, so he wasn't making an argument just that we're all in a Republican government, and so everybody's committed to a Republican government. We just don't like the president in power, so we get to criticize the people in power, but you don't get to criticize sort of the constitutional order as a whole. And he would say, you can criticize the constitutional order as a whole. I mean, burning an American flag is actually not necessarily a criticism of the constitutional order as a whole. It might be a criticism of the particular administration in power or a particular act. But I think very obviously that's a critique of the government in some way, or expressing discontent with some facet of it, including and up to like the whole thing, right? That I think the constitutional order ought to be destroyed and we need to put something just in its place, right? I mean, constitutional government's going to have to allow for that kind of criticism. And I think freedom of speech in a popular government where the individual gets to make those judgments in the end is sort of well within the bounds. So, I mean, high school students and up wearing black armbands to protest war, I think obviously count as freedom of speech. What was your other example? You had yeah. Yeah. Oh, the kneeling during the pledge. I mean, I think, yes, I guess the catch would be that depending on where you're doing it, I mean, I guess so if you're at Knox, it's a private institution, I think I take it you're committed to general, where's your president? He's not here anymore. I'm assuming Knox is committed to ideas about freedom of speech and exchange of ideas. So presumably, if Knox has is there a flag in here actually? But so if you have a pledge, I would presume Knox would let you kneel during it. But I mean, those are questions that can also turn. I mean, clearly, if there's a Pledge of Allegiance and the government's the one running the pledge, University of Illinois, right? Yes, you would have to have a constitutional right to be able to, not stand for the pledge, not engage in the pledge, kneel in the pledge. Now, whether like you're a sports player and you're on a private team, that's different. The First Amendment doesn't necessarily apply. Now, you might want to insist that those norms should apply, right? But and that's kind of an argument about the kind of citizenship I think we want and the kind of norms and customs we want within the larger political order.
Let's say we didn't have the First Amendment.
Okay, yeah.
Would the Alien Sedition Act still be unconstitutional based on a conglomeration of text and ideas behind the text?
I mean, yes, I think it would be. And it's an interesting way to actually think about how we think about the Constitution as a legalist document in some sense. And I think it would be, for all the reasons that Thomas Cooper and James Callender and Madison give you, in a popular government where power is rooted in the people, right, and the government is responsible to the people have to be able to say what they think about the government. You couldn't make it infallible. Right now, I mean, then there is a question from there, right, about distinctions about political speech against other kinds of speech. And for sure, right, I mean, when you're looking at the 1790s, they're talking about fundamental political speech, right? I mean, the very essence of self-government of a people. But when we think of the Bill of Rights, and I think this is an important point in terms of thinking more broadly about a civic or political constitution, rather than simply a legalistic version of it, when Madison got the Bill of Rights passed as a member of Congress, right, he was initially skeptical. And he was skeptical for reasons other Federalists, James Wilson, most importantly, who advocated the Constitution but were skeptical of a Bill of Rights, were skeptical. And they were skeptical because they were worried that you couldn't actually engage in a genuine enumeration of rights. And they were worried then that if you tried to do that, at some point, the government would start to say, well, you're really only entitled to the rights we've enumerated, right? And so in Wilson's argument, it was essentially that bills of rights are things that monarchies can create, because in a monarchy, and think about this in relation to Madison's argument about popular government, in a monarchy, right, you're assuming that the government has all the power, really, and the government then can carve out a space for you and say, okay, we're going to give you a Bill of Rights, and so here are some of the rights that we're going to grant you. Right? And Wilson said, but that's not how things work in a popular or constitutional government. In a popular or constitutional government, it's the people that have the power, and it's the people who hand over a portion of that power to the government. And so they don't have to say, and by the way, we have these rights, because they're like, well, we didn't turn those over in the first place, right? Now, Madison ultimately says, I'm going to give you a Bill of Rights. But he mostly, and again, I want to think of this partly in terms of how we think about original meaning. Like, can you really return to an original meaning and say, here's what this text means? The reason Madison gave us a Bill of Rights is because he wanted to stave off another constitutional convention. And the Anti-Federalists had a whole series of rights they wanted, but they also really wanted another constitutional convention because they didn't like the Constitution as it was being put forward and defended in terms of being ratified. And so Madison was like, look, they're going to agitate until we give them this, but if we give them this, I think I can take that political argument off the table. And he then says, all right, so we'll come up with this Bill of Rights. And partly he thinks that it will be beneficial, not so much because the rights will be legally enforced, how we think of them now, but because the rights will be a text of instruction. The people will understand their government and the rights that they have, and then they actually have to kind of work them out. So he thought it would be not just a means of civic education, but a means of cultivating the necessary thinking and habits about constitutional government on the part of the people. And so, from that perspective, I think you could get rid of the text of the First Amendment and still make all of the same arguments regarding why you have to have freedom of speech that he was engaged in.
So in a little bit different piece of this, I was struck when you were talking about 1790s, sort of the distinction between critiquing the president and critiquing the government.
Yeah.
And former high school social studies teacher. And one of the things that folks who are reading AP exams say is they can tell what country a student is from, because US students always talk about we when the government is doing something, and students from other countries talk about particular administrations or leaders.
Yeah.
And I'm just wondering about your kind of reaction in thinking about that in relation to what extent does that identification make it more difficult to distinguish the arguments, make it more difficult for folks in our current environment to make the kind of arguments that you're saying need to be made?
Yeah. No, that's actually a really interesting observation and a great question. And so what I would wonder a little bit on, to kind of tease it out, right, so if Americans are prone to then think, right, that when we're talking about the government, we're talking about us, we're talking about the political project as a whole, the citizenry, the government, it's all kind of the same. And so if we're thinking about that, what I'd want to know is, when we use that language, because what I can imagine is we're using that language and thinking about America, or the American Constitution, right, or the American political order in those terms, you know, from including the symbols of America. But if you then said, all right, we're talking about a particular administration, right, would they be likely to use we there, or would that is that where they'd be like, well, because what I guess I'm thinking of is, you know, we also, and this poses its own set of problems in some ways, we also tend to think in America we have this language of like, yeah, we, right, it's American, and that's why this administration is un-American. It's not we, right? It's something outside of that because we stand for this. This is not how we behave here. This isn't what we do. And in those instances, I guess I'm thinking they are kind of tacitly saying, right, the party in power, the people in power are breaking with something that's American, right? That's the we.
Well, and also sometimes thinking is we means a criticism is a criticism of me.
Yes, yes.
Right?
Yeah.
Because that is then part of it. And we immediately defensive around those criticisms.
Yeah. No, I think that's a really fair point.
All right, I think we've got time for one more question, so I can raise over here.
Sorry. I have a quick question, just out of curiosity. We've been talking a lot about the First Amendment, but in terms of the Bill of Rights, I also want to ask you a question about, in regards to like the Second Amendment, especially because it's becoming more and more relevant nowadays. How, as the person who pretty much, you know, drafted the Bill of Rights, how do you think Madison would interpret this Second Amendment in today's view? Because obviously it's like the right to bear arms, but the Declaration of Independence also said that every citizen has the right to life, liberty, and pursuit of happiness. Yeah. So do you think Madison would, like if he were alive today, do you think he would like alter like that perception, and especially with like the way technology has advanced now?
Yeah, no, that's a great question, and I don't want to duck the Madison part of that question fully. If I'm confident of channeling Madison on the First Amendment, I might just be less so on the Second, although not, I guess not really. But the part I want to say that's I think more important, and then get to the Second Amendment, is I've drawn on Madison and other thinkers to try to work through, to show how I think Americans in the past worked through these issues and did so as a part of ordinary politics, and that they were wrestling with constitutional issues, and they were trying to sort them out in their day, which didn't, I don't mean to say that they're just bound by their day in that sense, but the kind of question was in some sense forced upon them, and they were like, because if you look back about debates about the Bill of Rights, say, there aren't actually, so it's kind of shocking. You can look back at the Constitution, there are these extraordinary debates about the Constitution, right? I mean, the Federalist Papers, and you have a bunch of papers that we take to calling the Anti-Federalist Papers, then you have the Constitutional Conventions debating them, and there are these great records. So there's this enormous amount of material defending the Constitution, criticizing the Constitution. You can really look to the debates and gather the history of it together. When you get to the Bill of Rights, it's like, there's almost nothing. I mean, there's a little bit of debate, a little bit of defense, but so they're forced to say, you know, what do we mean by the freedom of speech? So, I mean, so Massachusetts' Constitution, Virginia's Constitution protected freedom of speech in the press, but they didn't really think, so do we mean the British common law inheritance? Do we mean something else? And so, you know, one of the things I would want you to get from my talk the most is to say, and Madison can be incredibly helpful in thinking about these issues, as can lots of thinkers from our past. But in the end, most of these questions we've got to really wrestle with ourselves, right? And they can be helpful in thinking about them, but we have our own context, right? We have our own understandings, and you're within the constitutional scheme, and this is what I want to say, you're always, in some sense, having to go beyond the text. the Constitution's trying to do many things at once, right? I mean, it is trying to provide, I mean, so I think Madison would say there is clearly a right to self-defense, and that includes a right to be armed. Does that include a right to own an, I always get mine confused. AK-47 was the thing the recent guy had, an AR-15, right? Or those are different things. Does it include a right to own those guns? That's a way different question, right? And so you could say there's a right to self-defense, but then, what does it entail beyond that? And, can we, in our circumstances, say, well, wait, some of these weapons seem like, you don't really need that much for self-defense in some sense, or they can be used for other reasons that are clearly a problem. And it's right part of the political community that we inhabit now to make some of those judgments. Right? And so even if you have a right to self-defense in there, which interestingly, it's not clear the Second Amendment clearly confers. Again, I think Madison says it would be there generally. That doesn't mean the Second Amendment is where it's totally rooted. But then we have to make judgments about, what do you do in our time, in our place? You didn't have AR-15s in 1790. Does that simply change things in a really important and powerful way? And those are the kinds of questions I think that we need to wrestle with as a citizenry, and we shouldn't shy away from wrestling with.